And we begin tonight with a constitutional question that could determine whether Donald Trump appears on a state ballot next year. The House January 6th committee laid out in stunning detail the events of that day, using video evidence to show meticulously how Donald Trump summoned the mob, assembled the mob, and lit the flame of the attack. Now, an historic trial is underway in Colorado to determine whether Trump should be disqualified from appearing on the ballot in 2024 because of his role in inciting the events of January 6th. The lawsuit, filed by 6 Colorado voters with the help of watchdog group Citizens for Responsibility and Ethics in Washington, argues that Donald Trump is ineligible to hold office again under Section 3 of the 14th Amendment, passed after the Civil War. It prohibits anyone from holding office who, having previously taken an oath to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. Lawyers for the plaintiffs argue that Donald Trump violated his oath of office, trying to overturn the 2020 election, leading to the attack on the Capitol, which was an insurrection. Trump's attorneys argue the lawsuit is an effort to get the court to endorse the House January 6th committee report. Washington, D.C. police officer Daniel Hodges was the first witness to testify on Monday. He spoke about the injuries he received that day after being crushed in a door and, as he testified, being punched, kicked, beaten, and sprayed with pepper spray.
I was afraid for my life and for my colleagues. I was afraid for the people in the United States Capitol building.
California Congressman Eric Swalwell also testified on Monday about how he and other lawmakers monitored Donald Trump's comments as insurrectionists breached the Capitol to try to stop the certification of the election. Colorado's Secretary of State, Jena Griswold, is named as a defendant in addition to Trump. The suit would force her to bar Trump from the ballot. Griswold has said that she will comply with whatever the court decides. Other secretaries of state in battleground states have also grappled with the issue of the insurrection clause. Arizona's Adrian Fontes has said the issue is an unanswered question and up to the courts, not to him. New Hampshire's David Scanlon said he had no legal basis for invoking the 14th Amendment and wouldn't block Trump. And Georgia's Brad Raffensperger claimed in a Wall Street Journal op-ed that he can't block Trump, and it should be left up to the voters to decide. And that illustrates the two questions at stake. There is the legal question that will continue through the courts. Colorado's trial is only the first litigation on the insurrection clause. Last month in California, legislators asked the state's attorney general to seek a court opinion about whether Trump is disqualified under the 14th Amendment. And Trump faced a similar lawsuit seeking to disqualify him based on the 14th Amendment in Minnesota and Michigan. Michigan Secretary of State Jocelyn Benson has said she won't keep Trump from the ballot unless the courts direct her to. And today, Donald Trump filed an injunction to try to prevent her from blocking him from appearing on the ballot. Then there's the political question: how it looks to voters if secretaries of state are the ones to make the call to keep Trump off the ballot. Colorado's Jena Griswold responded to that point.
I'm a Democratic Secretary of State, and I did not bring this case. I'm actually a party as a defendant because I certified the ballot. And I would just say, look, Colorado Republican and unaffiliated voters brought this case. I think it is very reasonable to determine whether the U.S. Constitution is in play. If there's something unclear, it's an appropriate mechanism to file a lawsuit. What is inappropriate is trying to steal an election from the American people.
I'm joined now by Maryland Democratic Congressman Jamie Raskin, member of the Select Committee to investigate January 6th and the House Judiciary Committee, as well as the lead impeachment manager in 2021. And Lawrence Tribe, professor emeritus at Harvard University. I am lucky enough to have not one but two constitutional scholars in front of me right now, which is really exciting to get to talk to both of you. So I just want to ask each of you in turn to just give us your evaluation of the merits of this case. It was brought by 4 registered Republicans and 2 unaffiliated Colorado voters, and they have until March 5th to decide. That's when the primary is in Colorado. I will make deference to the congressman and go to you first, sir. You know the facts better than any of us who are sitting here about what Donald Trump did on January 6th. Is this case meritorious in your view?
Well, I should yield to my constitutional law professor, Larry Tribe, who taught me everything I know about the Constitution. But let me give you my sense of it, Joy. I don't really understand people who control access to the ballot saying, well, we'll let the voters decide. I mean, if someone showed up trying to run for president at 19 years old, their answer wouldn't be, well, let's let the voters decide. They would say, let's consult the Constitution, which says you got to be 35 years old in order to run for president. If Jennifer Granholm, the Secretary of Energy, showed up, or Arnold Schwarzenegger, both of whom were born abroad, and they'd try to run for president, I don't think anybody would say, well, let's just let the voters decide. They'd say that violates the rules of the Constitution, which says you have to be a natural-born U.S. citizen. And it's the same thing here. The question, the hard question, is not should the courts end up deciding, because the courts will have to decide this because it is a constitutional question. The hard part is, did he engage in insurrection or rebellion? That is the hard part for some people. Is incitement to insurrection participating in insurrection? The House of Representatives already impeached him for inciting insurrection. 57 of 100 senators voted to determine that he did engage in incitement to insurrection. So you've got robust bipartisan bicameral majorities defining that as a legislative fact. But I think the alternative argument will be, no, you need somehow a criminal conviction first. It's not enough to show that it happened. And, against that, I would simply say the language of Section 3 of the 14th Amendment says that you can't run for office if you've sworn an oath to the Constitution, but then you've participated in insurrection or rebellion. It doesn't say if you've been convicted of insurrection or rebellion. But I think that will become really the heart of the legal argument.
Now that I have allowed your former student to show you that how much he learned, I will not ask you to grade him, Professor Tribe, but I will now turn it over to you. Now, in this case, the 14th Amendment actually has been used. This was used to remove from office a New Mexico County commissioner who entered the Capitol on January 6th. Now, there was a legal trial for him doing that. So it has been used in the past. But I would love to hear your take on the merits of this case. And I will just really quickly say that the judge would like these things addressed, and you can respond to it. The history and application of Section 3 of the 14th Amendment. Is Section 3 self-executing, which I think is an important question. Does it need to be executed by others? Does Section 3 apply to presidents? The meaning of engaged and insurrection as used in Section 3, and did Trump's actions meet the standard for Section 3? Your thoughts, sir?
Well, I think the answers to all of those questions are quite clear. It is clear that Section 3 by itself says that anyone who engages in an insurrection or rebellion against the Constitution of the United States, that's the phrase, not just against the government, but against the Constitution of the United States, is not entitled to another bite at that apple. Now, Donald Trump says it might apply to a county commissioner in New Mexico, but it doesn't apply to him, because it doesn't apply to the president. That is an absurd argument. I won't go into the details, but it's clear that if there's any officer in the country who would be a danger to democracy if he were allowed again to manipulate our processes, it is someone who took the oath as president and then turned around and tried to overturn the central part of the Constitution, which is the transition from one president to another in accord with who actually wins the election, not who says, I believe I won, I thought I won, I should have won, how could I have lost to this guy, but the person whom our legal process determines as the winner. Now, one of the things that Mr. Trump, and by the way, in the Michigan filing today, he calls himself President Trump 35 times. He seems to think that he won the election, but I have news for him. The Constitution says that you serve for only 4 years. And if you lose the Electoral College, that's the end of it. He argues, I never really took the kind of oath that Section 3 talks about. It talks about an oath to support the Constitution. I didn't take that oath. I took the oath that the president takes. It's an oath to preserve, protect, and defend the Constitution. Now, that's how ridiculous the arguments get. The legal arguments are clear, but the political argument is not so clear. A lot of people say, even though Congressman Raskin's examples are perfect, they wouldn't apply it to a 30-year-old or to someone not a natural-born citizen. But they say, let the people decide, even if someone is not eligible. That's not the way the people who fought the Civil War decided we needed to handle it. They decided that you needed to disqualify anyone who basically is a traitor to the Constitution. That kind of person is dangerous. Dangerous as a person who might attempt to seize power and then never let go. That's the history of autocracies around the world. Somebody manages to make it into office, and then they decide they're going to stay. Yeah. That's the danger against which this language is designed to protect us all.